If you apply for a license to carry firearms in Massachusetts and you're denied, you have 90 days to appeal that decision to a district court. The same goes if you had a license to carry and it was suspended or revoked by the chief of police. The official name for the appeal is called a petition for judicial review, and it's filed in the district court that has jurisdiction over your city or town. And then the real meat of the appeal is the hearing. They should really call it a trial because it's a trial in front of a judge rather than a jury, but it's a trial, all right. Basically, you have a right to present evidence, you have a right to call witnesses, so does the other side. And a judge will ultimately decide who's right. But here's the thing. The police have the obligation to prove that there's credible evidence that you would be a public safety risk with a firearm. If you're a prohibited person or you have a disqualifying conviction on your record, this may not be the right route for you. You may have to take care of that disqualifying conviction prior to applying, and that's a whole different route and that may be possible. These hearings are about suitability. Was the police chief justified in their decision? Did the police chief have credible evidence that you would be a public safety risk with a firearm? Many times I've had cases where the police simply deny somebody or suspend somebody because they've been charged with a crime. Now that's not enough in and of itself. I've had many cases where the police chief doesn't do any investigation or do anything to substantiate whether those underlying facts are actually true. My argument generally is that the police chief was arbitrary and capricious in coming up with their decision. I've had a lot of cases where the judge agrees and overturns the chief's decision. Many times when people were initially denied or suspended, their licenses to carry have actually been turned back over per court order. Obviously, nobody can guarantee success, and every case is unique. But there are certainly a lot of cases that I've experienced where the chief's decision was arbitrary and capricious and where there was no credible evidence of my client being a danger or a public safety risk, and the court has agreed.